Chief Justice, my name is Alan Shi, and here's my question. Do you consider yourself unusual as a Canadian woman who has achieved one of Canada's most prestigious and important jobs? Can you explain your experience as a woman in the justice system with any thoughts you have regarding why there are fewer women in top jobs in Canada and how that might change?
Thank you. That's an excellent question. There are two questions, really. My experience, and secondly, what do I take out of that experience vis-a-vis the fact that there are fewer women than we would like in top jobs? Well, I think we have to look at these things in historic perspective. As I mentioned in my little talk, when I started, there were very, very few women who were going into professions like law or medicine or anything else. There were certain jobs women were thought able to do, like nursing, secretary, being a mother, and homemaker, of course. But there were very few, a teacher, there were very few others. And while a few brave women had tried to do that, there were very few women. And this was the way society was ordering itself. We've gone through what's called the Women's Revolution, and we now, in our country, recognize that women have the right to make choices about their future and be whatever they want to be. And I would encourage you to take that as your guide principle. You can be whatever you want to be. You're very fortunate to be born in this time when there are fewer barriers against women entering any profession they want to, be it an airline pilot, a lawyer, whatever it might be. And of course, there certainly were when I started practicing, and there still are to some extent barriers that make it a little bit harder for women in some circumstances. One of, I think the entry barriers have been knocked back. We have, as I mentioned, more than 50% of the law classes are made up of women. And women enter the profession in large numbers. But what happens in the case of law that we have noticed is that after a few years, some of the women drop out more at a greater rate than men. And this has to do with family, I suppose, and the fact that in our society the main responsibility for childbearing and child rearing rests with women, so the profession of law is trying to deal with this, trying to encourage law firms to find new arrangements, be more flexible. I hope by the time that you're facing the development of your careers, there will be even fewer barriers, and that you will not, that women in the years to come will take up more and more of those high positions. Thank you.
Thank you very much.
Hello, my name is Alberto, and I would like to ask Chief Justice, which of these three do you believe is the purpose of the criminal system? The punishment of the criminal and rightful retribution, the prevention of future crimes and protection of society, or the rehabilitation of criminals and resolving the roots of crime?
Thank you. Well, the criminal code says that all of those are the goals of the justice system and the criminal justice system. So that's what Parliament has told us, so we have to accept it. Now, I think what you're really getting at in your question, and it's a profound one, is that sometimes these goals come into conflict. And so a judge who is, for example, faced with the task of sentencing, which is one of the most difficult tasks I think judges face, has to think about punishment and has to think about crime prevention and deterrence, and has to think about rehabilitation all at the same time. And sometimes, at least on the surface, these can seem to conflict. What the judge has to do is find the right answer bearing all of those things in mind. It can't just be vengeance or punishment. Our criminal code doesn't allow that. It says you have to take into account the rehabilitation of the offender, and you have to take into account deterrence and so on. So judges try to follow the directions of the criminal code and impose a sentence in accordance with what has been set out in that law.
My name is Nathan MacDonald. Chief Justice, could you tell us how judges determine community standards in issues such as public nudity? For example, the public might appreciate seeing me in the nude, but not the Prime Minister.
You'll be relieved to know I'm not speaking for the Prime Minister, but I could not do so. But you've raised a really difficult issue. There are certain laws where judges are required to go back to the notion of morality, for want of a better word, public standards of morality. You've mentioned some of them. Pornography is another area that raises these issues. These are laws that are in the criminal code, but have reference to standards of public morality or some similar standard. And it's very hard for judges to do. We're told by the criminal code we have to do it. We have to come up with an answer. And we rely mainly, I think, on the materials before us. As you know, and when a case such as this goes in, one can expect evidence to be called. One can expect the prosecution, the Crown, to call evidence on why they think this breaches standards of public decency or morality. And so the judge will look at what the prosecution has put forward in evidence, and the judge also looks at what the defendant might have put forward, and the judge then, using his or her common sense, tries to come up with a decision, must come up with a decision, but balances these things and decides what in the circumstances of that case is the threshold. So I would emphasize that it's not something that comes out of the judge's head. It's not my morality or my sense of decency as a judge. It should be based and is based primarily on the evidence that is put before you in a particular case. Also, other cases that have been decided in areas, in a particular area, for example, pornography and so on, will help us decide what goes beyond the bounds of the criminal code. Because, as you know, we have a system of stare decisis. So if there are other cases saying this kind of conduct or this kind of communication or whatever it is violates the standards of public morality or whatever that standard is in a particular law, then we can say, yes, we have guidance in that previous decision, and it helps us in making a decision. But it's not a subjective decision of the judge. It's a legal decision.
Thank you for the time.
Chief Justice, my name is Adiba Chowdhury, and could you please comment on the issue of access to justice for Canadian citizens from all levels of society? What barriers have been established and what assistance is available?
The basic principle is that every Canadian man, woman, and child should be able to have access to the legal system and to justice. And the reality is that it's often a difficult thing to make this happen. What are the barriers? Cost. It can cost a lot of money to hire a lawyer and pursue a lawsuit through the courts. So that can be a barrier. Another barrier can be time. It can take a long time. And there's a saying, justice delayed is justice denied. So you can have a denial of justice because it takes too long. Those are two barriers. How do we reduce the cost and delay in litigation? We're working very hard, and it's an ongoing process. The courts have been working hard for years. We try to ensure that the rules that govern how you bring lawsuits are structured so that people can have access, so things don't take too long or cost too much. We have legal aid systems in place for serious crimes, for the defense of serious crimes, for family matters, and certain other matters. And that will help a person who doesn't have money have access to a lawyer and pursue their case or defend their case in court. We have other mechanisms like contingency fee arrangements where the lawyer agrees to, rather than charging by the hour, to take a percentage of anything that is won in the action. And that will allow people who may have been injured, for example, in a motor vehicle accident, but who may not have a lot of money to pay a lawyer up front, to get to the courts. We have what we call pro bono, which is the legal profession lawyers working for nothing. And this is not as much appreciated as understood as it should be. Most large law firms and many independent and individual lawyers have programs where by a portion of what they do for nothing. They do it for people who could not otherwise afford legal services. So through all these ways, we are trying to make sure that justice is affordable and that everyone can have access to justice. There are many other ways, for example, that we are helping. There are programs in the courts where you get information if you're bringing your own lawsuit, and there are hubs you can go to get information and be directed in the right direction. I can only tell you that the bar and the judiciary is working very, very hard on this problem, and while we recognize that we're not where we should be at the moment, we're working very hard to ensure that we get there in the shortest time as possible.
Chief Justice, my name is Someya Genbari. I'd like to ask you, what was the most difficult decision that you had to make as a judge?
Well, I always get asked that, and I always flub the answer because there have been a lot of difficult decisions, and really it's hard in retrospect to say this one was more difficult than another one. You listen to the lawyers, you read the materials, you think about a problem, you listen to your colleagues, and gradually out of that comes some sort of conviction or answer as to how the case should be decided. And the process is never easy. Sometimes it's more difficult than others. Sometimes I have reversed my mind. I've changed my mind from what it was after the hearing. I think about it more. I come to a different decision. There's another element that can be difficult, which is sometimes judges have to make unpopular decisions. You know that what is right on the law, as you understand it, and honestly apply it, may not go down well with the public at that particular time. And yet judges have to have the courage to make those decisions. That's their job. For example, the Persons case, the case which back in 1929 held that women could hold public office, nowadays people say, well, that was a no-brainer, that was an easy decision, everybody must have been happy. If you go back and look at the editorials at the time, they were outraged. The people thought that was one of the worst decisions ever. But I tell you this story just to say, judges have to be prepared when it's required for justice to sometimes make unpopular decisions, and that can be hard too. So I've given you a generic answer. I haven't pointed to a particular case. I hope you accept that.
Chief Justice, I got a question, but I had the opportunity during work experience to sit during a trial, and the person accused previously had a bunch of break-and-enters and assaults and charges laid against him, which were pretty bad. He only got let off with a warning. I believe that was his 6th warning. I want to know your thoughts on that.
Yeah, well, I find that a little surprising, but I can't comment on a particular case. As I understand it, first of all, I'm not sure people just get let off only on warnings. There would have to be some sort of a disposition, a conviction, in which case there are certain things that have to happen. It could be a conditional sentence or something like that, or there's an acquittal, in which case the person's free. What the judge might have done is said, I'm imposing a conditional sentence, for example, or something like that, but I'm warning you that if you don't keep the conditions, then you will be in prison. That can be done. But it's hard for me to comment on a particular case, not knowing exactly what happened. I think what you're getting at is that you're concerned that judges are too lenient in the sentencing. My answer to that is that judges are governed by the criminal code, which sets out a range of sentences, including certain minimum sentences, which judges apply when they're there. These are set out by Parliament. Parliament has also set out a variety of goals, including rehabilitation, which a judge is required by law to bear in mind. So in a particular case, the public might be saying, throw the book at this person, but the judge is obliged by law to look at whether that person can be rehabilitated. So we find that often when people understand all the facts and circumstances, they're quite able to accept sentences, but when they see only a little part of it, they might not understand it and they might object. I'm not saying that every sentence is perfect, but I do say that there is an appeal process that can be taken and often is taken by the Crown, the prosecution, if they feel a sentence is too light. They're the government agents, they're the people who are out there who should be doing that appeal and taking it if they feel the sentence is too light. Also, of course, Parliament has a role to play and in saying what kind of sentences they think should be imposed. And I don't think I can do better than that. It's a difficult question. I know that often there's a public perception that people are being treated too leniently, but we have to bear in mind that Parliament has set up sentencing options such as conditional sentence and has told judges that if these circumstances are met, A, B, and C, I won't go into them now, then the conditional sentence is appropriate and you should consider it and if appropriate, impose it. So judges are trying to do a difficult task to act within the mandate that Parliament has given them. And I know that sometimes people differ with that, but the proper approach, the proper remedy is for that to be appealed.
Chief Justice, my name is Emma Sharoma, and I have a question. Some people have said that with the 1982 Canada Act, including the Charter of Rights and Freedoms, that decision-making power has shifted unfairly from elected representatives to appointed judges. Can you please comment on the complexities of this topic and how this situation actually benefits Canada?
That's a good question. I touched on it a little bit in my comments. There is no doubt that the adoption of the Charter in 1982 meant that judges would have to rule on whether government laws and government actions conform to the Charter. Do they violate these rights, this right, that right, freedom of religion, freedom of expression, the rights of those charged with offenses and so on? Do they limit those rights, and if they limit them, do they do it in a way that's it can be justified? If not, then there's a violation, and it's up to the courts to do this. And when the Charter was adopted, politicians knew that they were going to be giving the courts a lot more responsibility in this area. And it's not a responsibility the courts can shirk. We have to answer the questions. If a litigant comes before us and says, my rights have been violated, the court can't say, go away. They have to rule on the case. So yes, judges have more power under the Charter. We try to exercise it very responsibly because we too are limited by the Constitution. And we have great respect for parliaments and the legislature's decisions on when they pass a law. We approach it with deference, but if it is clearly violative of the Charter, a judge has no choice but to say, we think it is inconsistent with the Charter. This is a role that constitutional courts play all around the world. It's nothing unique to Canada. The United States Supreme Court does it. The House of Lords is doing it now in England in a certain way vis-a-vis because of their Bill of Rights, which comes from their association in the European Union. South Africa does it. I could go on, and Israel does it, and go on and on and on. This is a basic role that courts have to play in a constitutional democracy, which has a Bill of Rights, which is constitutional. And we try to do it responsibly. We try to do it in a way that's respectful. And your final question was, is this good for democracy? I think it is, because it ensures that there's a balance between individual rights and government power.
I just wanted to ask what you thought many Canadians perceive of Canada's change in direction internationally. We are now instituting mandatory minimums for crimes related to handguns, cocaine, and marijuana. We are also sending back war resistors to the United States where they may face harsh prison punishments. And we are refusing to stand up for Canadians who are facing capital punishment overseas. And I'm just wondering what you think of that particular change in direction.
Well, you're you're referring to political acts, and they're not within my domain as a judge. I think it would be wrong for me to give you my personal opinions on what is essentially a political matter, because I'm a judge. If those matters come before us in a proper legal question, I will have to rule on them. And if I were to give you my answer now, then the appearance of impartiality that I must as a judge maintain would be marred. So I take note of what you say. I know many Canadians are concerned, but I have to beg the question. I have to say that as a judge, I can't get into this because these are issues that could come before us. And that being the case, I don't think I should pronounce on them until they are properly before us in legal fashion.
Chief Justice McLachlin, I have two questions. As a judge, how much of your day is consumed by your profession?
Okay. Well, I usually get into the office at 8 o'clock, and I try to get out by 5 or 6. I might do some work in the evening too. So it's quite a bit, but it's manageable. I love my work, and if there's something to be done, then I take great pleasure in doing it. But you know, I've always believed you have to have a balance too between life and work. You have to, as a judge, maintain a perspective. You can't just isolate yourself from society. So I also like to, you know, walk my dog and enjoy a dinner with my husband or friends, go to the odd concert. I don't think judges have to live a life of all work and no play.
And my second question was there any decisions that you have made personally that you have regretted?
Judicial decisions?
Yes.
You know, not really. Because in this, let me explain it this way. There might be decisions occasionally that I think, well, 10 years later, maybe I would have decided that in a different way. But at the time, no. I think what you have to realize is that you do your best at the time. You have arguments before you. You have precedents in other cases before you. You look at that, you look at the facts, you struggle with it, and you come up with the best answer that you can at the time. Now, 3 or 4 years later, something may come to light that suggests that wasn't such a smart answer. You know, society changes, we learn more about certain things. And of course, you might say, gee, if I'd known that then, maybe I would have made a different decision. But, you know, life is such that you do what you can. My goal is simply to decide each case before me as best and as conscientiously as I can. And then I have to turn the page and move on to the next case, because if I was continually preoccupied with looking back, second-guessing, I wouldn't be able to go forward and do the work that I have to do for the future. So we have a system of, this is one of the great things about democracy. as things change, adjustments can be made. Parliament can change the law. They can respond to a judicial decision that they think may not any longer be very functional by changing the law. The Supreme Court itself sometimes takes a second look at previous decisions and says, no, that was wrong. We should change that. And so there is a flexibility in the system, and that's what gives me comfort. Thank you.
It is an honor. My name is Andy Dang. I apologize if my question may be a little bit open-ended. Society has a certain standard, and the laws reflect the beliefs and culture of its society usually. What would you say is the focus of the majority, in your opinion, as in what issues and concerns are usually brought up to you?
Well, that's a very broad question. It depends on the nature of the case, of course. We can hear a commercial case, and the concern might be how well a particular decision will sit with the commercial practices, or what it might do to business or something. Or you have a constitutional case where your concern is how is this going to affect governance or individual rights. Or you have a family case where your concern is how is this going to affect the children and the marriage. I mean, the concerns vary with the case.
Chief Justice McLachlin, my name is Martina. I would like to ask that the recent tasering incident at Vancouver International Airport is an area of law that is a growing concern. International security is becoming a part of everyday Canadians' life. So I was wondering, do you think that this is an area that the Supreme Court might have to get involved in?
Yeah, we have already been involved in it. Last February, we issued a decision called Sharkawi, which had to deal with the law that permits detention of non-citizens, people who would be immigrants or refugees, who are thought to pose a security danger to Canada. And we ruled that law was to some extent unconstitutional because it did not provide sufficient protections for people detained. We recognized that security was a very, very important goal, and that total disclosure to the detainee might not be possible, but we felt that that better measures could be taken than had been set out in the bill. Parliament has now responded with another bill in which they are proposing to change the law to set out better measures. So this is an example of how the courts and Parliament interact on a security issue. Thank you. Thank you so much. It's been a real pleasure I've really enjoyed this, and I really want to congratulate you and your teachers for coming up with this format, which makes it possible for us to exchange ideas and for you to talk to me and vice versa in a way that is so easy and I think so successful. I really enjoyed it. Thank you very much, and good luck to you all in your future.